All rise. 33rd District Court is now in session. Honorable Michael K. McNally presiding.
Be seated, please. Good morning. So I gotta apologize. I never get them out here this late, never. I bet I haven't been out here this late in 30 years. So I had to meet with the Region 1 State Court Administrator, Judge Coleman, and we had a nice conversation. He wanted to come out and meet us. So we've been sitting in there for an hour. I apologize sincerely to all of you. This is not what I do here. Okay, sorry. Matthew Ray Hargis, 25F243821.
Good morning, Your Honor. Attorney Connor Pearson, E87-850 on behalf of Mr. Matthew Hargis. Sorry, please say your name for the record.
Matthew Hargis.
All right, so your client pled guilty to, to the charge of operating while impaired on July the 10th. I referred him for a screening and assessment. Have you had the opportunity to review the report with him?
Yes, Your Honor. There's a couple things I wanted to shed some light on as it relates to the PSI report.
Okay.
So under the page 2, under the drinking style and treatment history, it says he's never been involved in substance abuse treatment. So that's actually not quite accurate. He's had a substance abuse evaluation with Serenity Therapy and Raj Mehta. So I just wanted to make sure that that's correct.
Okay, I'll modify the report in that aspect.
And also, as regards to the recommendation, he's actually already completed Mothers Against Drunk Driving Impact Panel and has actually donated $500 to the program. So I just wanted to make sure you're aware of that.
He donated $500?
Yes, in addition to attending the program.
Okay, well, that's awful kind of you.
And the rest, I just had the rest for allocution.
Okay.
So he's 38 years old. He's a very close relationship with his family. He has a mother, father, 2 sisters. He actually is from this community. He graduated from Southgate Anderson High School in 2004. He's married. He's the father of 1 son, a 1-year-old. He graduated Michigan State University with a bachelor's in science. He does have a criminal offense. He has an MIP and a no tolerance OWI from his time at MSU. But he has since overcame those challenges. He's a certified therapeutic recreational specialist, and he owns his own practice called Semeco Recreational Therapy. Did I say that right? Semeco. And it's actually pretty inspiring, Your Honor. He's really, you really can call him a modern day miracle worker. So he works with people who have had traumatic brain injuries and who have several impacts on their day-to-day lives, and people who have like cerebral palsy and different patients with very debilitating conditions. So one example that I thought was really moving to me, so we had a patient who could barely walk more than 100 yards without a wheelchair. And Mr. Hargis has worked with this person over the course of the year, and at the end of that year, this person was, 92 years old?
No, that was the different.
Okay, so this person, over the year of working with Mr. Hargis, went from not being able to walk 100 yards to walking the whole Mackinac Bridge on Labor Day.
Nice.
So this person, incredibly smart person, incredible asset to his community, and has just been a service to others. As far as the incident that brings us here today, it's definitely a low moment for Mr. Hargis, but I just want to point out a couple things. He's been cooperative with law enforcement. No one was injured during the incident. He has taken responsibility and accountability for this incident. Like I mentioned earlier, he's already completed the Mothers Against Drunk Driving Impact Panel. He's donated $500 for that cause. He's completed a substance abuse evaluation, and as part of that evaluation, completed a substance abuse education prevention program. He continues to do 12-step meetings. He's had perfect bond compliance. As far as his conditions for this court. Also, with the impaired conviction, he will have driver's license restrictions, so it's already taken care of by statute. And so with that in mind, we just asked the court to adopt the recommendation with limiting testing requirements and driving restrictions so Mr. Hargis can continue to serve his community and his patients.
Okay, thank you. Sir, is there anything you'd like to say?
Yes, Your Honor. I'd like to apologize to the citizens of Flat Rock and Gibraltar for putting them at risk on May 17th. I'm well aware of the potential consequences of my actions as some of the patients that I see are a result of an alcohol-related motor vehicle accident. I'm very sorry for my actions. I'll do anything that I can to make amends and make sure that this never happens again.
Okay, well, all right, good enough. Well, I'm impressed. I'm impressed that you're taking responsibility and just overall what I'm reading here. I'm going to place you on probation. I'm going to make it for 10 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number. You do have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you submit to chemical testing, PBTs, and ETGs. I'll go along with that monthly. I'm going to order the victim's impact, but all I need you to do is provide proof. I made a note, attended, provide proof. So you just have to provide us with proof that you've attended that. Go to AANA at least once a week until you're in outpatient treatment. Once you get in outpatient treatment, you don't have to attend AA or NA any longer. I'm going to order 3 days jail credit, 1 serve 2. I'll let you serve those on by way of community service. So 2 days community service in lieu of jail, and I'm going to give you until September 10th. So 16 hours community service by September 10th. $300 in fines, $250 in costs, $75 victim's rights fee, $50 justice assessment, $675. Probation fees are $200 for $875. You have cost of recovery of $150, bringing the total to $1,025, and then you have a screening fee of $60. Your total is $1,085. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, Your Honor.
All right, so we have $1,085, and you can go down the hall. Can you pay that today, counsel?
Yes, sir.
All right, anything else? Any questions, either one of you? Anything?
Nothing for me, Your Honor.
Anything?
No, Your Honor.
All right, again, I cannot tell you how sorry I am we got out here so late. The meeting just went longer than I thought. My apologies. Good luck. Thank you.
Your Honor.
Thank you very much. Noah Russell. Do we have Noah Russell? Noah Drake Russell?
They're on Zoom, Judge.
Yeah. 17M705-9662FY. All right. Mr. Russell, your name?
Noah Russell.
Counsel?
Your Honor, good morning. Nader Nassif, P72557, appearing with and on behalf of Mr. Russell.
Do we have the detective out there on this? This is state police.
No, Judge, this was an older case. I couldn't get a hold of anyone.
All right. So, counsel, for purposes of arraignment, how does he wish to proceed?
Your Honor, we'd wait for more readings, stand mute.
All right. So I'm going to advise you of your rights, sir. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by your lawyer, not only today, but at all subsequent court proceedings. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference will take place on August the 5th. That will be at 9 o'clock in the morning. You'll be in front of Judge Hessen. And then preliminary exam will take place August the 12th at 11 o'clock in the morning, okay? So August 5th, 9 o'clock, August 12th, 11 o'clock, preliminary exam. The preliminary exam is, to this count, the people have to show that the crime was committed, excuse me, and that you were the one who probably committed the crime. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that, then that charge would be dismissed. Do you understand that?
Yes.
All right, so, counsel, I'll listen to anything you have to say regarding bond. Where has your client been on this?
Your Honor, my client is a resident of Ohio. He lives in Southern Ohio. This was a case that he was visiting and never was informed or never knew, obviously, about any felony charge. The way that he found out about this is he was looking to get his insurance license in Ohio, and through the background check, this came up. Once he learned about this, he immediately retained counsel. We've been working through that at this point. So, Your Honor, I would ask for a PR bond. I expect that he will abide by all court orders. And Your Honor, frankly, there are some issues with the case itself, being that the laws have changed regarding marijuana as well. So I would ask for a PR bond with standard conditions.
What kind of a record does he have?
No other record, Your Honor.
$10,000 personal bond. You can leave the state to go to Ohio. You cannot violate a law. You must appear in court as directed, no alcohol, no marijuana, or illegal drugs. And we're going to give you those dates. So you just have to, you can appear by Zoom on the 5th. You do have to appear in person, obviously, for the exam. Okay. Anything else, counsel?
Nothing further, Your Honor. Thank you.
Any questions, Mr. Russell?
Nope.
All right. Best of luck to you. Thank you.
Thank you, Judge.
Thanks. Chantel Ruel Williams, 25. Let me see. 25F2444198. Your name?
Chantel Williams.
Okay, you need time to pay?
Yes, please.
How much, do you have anything today?
No, sir.
When can you pay this?
Can I be given 2 weeks?
Yeah, do you want to set up a payment plan? What do you want to do?
Yes, that's what I was initially trying to do.
Okay, how much can you afford to pay? You just tell me when you can pay it. If you want, we'll set up a payment plan weekly or bi-weekly.
Can we set up a payment plan bi-weekly?
Sure. And you want to start in 2 weeks?
Yes.
How much can you pay?
Can we do 50?
Sure. You pay $50 bi-weekly, okay?
Thank you.
And I'm going to start this beginning. You did the right thing coming in, by the way. I wish everybody would do this. You pay 50 bi-weekly starting August the 8th. If you don't have the money, just call the court. We'll go on Zoom, or you can walk in here on or before the due date. I'll be more than happy to give you an extension.
I appreciate that. Is there a way I can just mail the payments?
Yeah, they'll explain everything down the hall to you, okay?
One more question, Alan.
Sure.
I was wondering, is there a way to maybe ask for the fines and the fees to be taken off?
Do you have insurance now?
No, I'm working on it.
Why didn't you show up here initially? That you had a extra fee. Why didn't you show up?
Initially, honestly, I was not given notification. And
Where do you work at?
I work with the airlines, but it's not a lot of hours.
I'll tell you what, I'll reduce the fines and costs. I will do that for you. Reduce to $185, okay?
Thank you, Your Honor.
All right, best of luck.
Thank you.
Good luck. Thank you.
Do I just go to the front?
Yes. Okay.
Thank you.
You're welcome. Good luck. Mario Enrique Pereira. I hope I pronounced that correctly. Pereira. Perfect. 25R 514187. All right. Yeah, I gotta check something here. John, you have to take this back to, who's doing this? Mercure? Is it Mercure?
Yep.
Yeah, you have to have a seat right there, sir. Thank you.
What's wrong?
He needs to tell me whether or not there was an accident. There was an accident, minor injuries, no injuries, minor damage, whatever it is. Michael Jacob Collins, 25R 514159. Come on up to the podium there, your name?
Michael Jacob Collins.
All right. Okay, you're gonna plead to impeding, right?
Yes,
Who's Latasha Collins?
that's my mother.
Is she here?
No, I ended up telling her to stay home because I was just running here for football practice. For her to stay home.
All right, so you gotta, so we need you to, you gonna be able to pay these fines today?
I already paid.
Well, that's posted by her.
Yeah,
It's in her name. She gonna allow you to apply the bond?
yeah,
She is?
yeah.
Okay, so you're gonna have to talk to them down the hall to the charge impeding, responsible or not responsible.
Okay,
Do you plead responsible or not responsible?
I plead responsible.
Default judgment set aside, plea is accepted to impeding. 175 is your total. Go talk to them down the hall and they'll tell you how to go about that, okay?
Thank you.
Good luck to you. Good luck with your football, Ray. Ray and Craig, 25F244329. And could I have seated up here Guy Neely, Jacob Guy Neely? Have a seat up here. Your name, ma'am?
Raining crazy.
You're charged with operating with the presence of drugs. You have the right to a lawyer. Would you like one?
Yes, I do.
Okay, we're gonna set you up with a lawyer. And you can go out in the hallway and my court officer will bring the file out as soon as he gets here, okay?
Okay.
And then either way, you're coming back in front of me. Good luck. Jacob, Eugene, Dwayne, Key Neely, 25F244420A and B. Your name?
Jacob Eugene Dwayne Keegan.
We have to stop meeting this way. Huh? You were just in front of me yesterday, right? Yes?
Yes.
And then when were you in front of me on another case, right?
Yes.
You gotta stop coming in here, okay? I'll give you a lawyer, all right? Okay, you got another suspend, revoke, denied, and disobey traffic control device, all right?
Yes.
All right, go out in the hall, he'll set you up with a lawyer, okay? And either way, you're coming back in front of me, people against Urso. Anthony Jordan Urso, 25R252558. And could I have Gillingham seated at the table, my right, your left? Your name, sir?
Anthony Jordan Urso.
You're charged with assault and battery. You're here for arraignment and pretrial. You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes, Your
Would
Honor.
you like a lawyer?
Yes, please. Your Honor.
Okay? All right, you can go out in the hallway. He will take the files out. He will give them to a lawyer. Either way, you'll come back in front of me, okay?
Thank you, Your Honor.
You're welcome. People against Gillingham. Jordan Gregory Gillingham, 25F256840. Your name?
Jordan Gillingham.
Did you meet with your lawyer yet
Yeah. Yep.
today?
Yeah.
Okay, he's not in here, so I'm gonna have to have you have a seat at that table right there. As soon as he comes in, I'll call the case, all right?
I think these ones might be all Mr. King's.
I think these are all, yeah, that's Mr. Gates. Is Kelly Ferguson here? All right, Mario Pereira, sorry, 25R514187. You can come on up to the podium, state your name, sir. Name?
Mario Pricker.
All right, so I had to take this, have him take this back. It says no injuries, minor damage. You're gonna plead impeding, right?
Yes.
Responsible or not responsible to that?
Responsible.
I'll accept the plea, dismiss the failure to stop assured clear distance 195. You can go right down the hall and take care of that. You're all set. Good luck.
Sure.
Thank you. Ms. Ferguson, did you speak to Mr. Gaith yet?
Yes.
Okay.
I didn't get a hold of him, Judge. It just kept ringing.
Good, how are you? That boy. Can you, well, John's going out. I don't know if he's getting Mr. Gaith or not. Can you see? Rustle up, Mr. Yeah, and tell him. Thanks a lot. Thanks. Bye. Okay, as soon as the lawyer comes in, I'll call him, okay?
Yeah, no problem. Mr. Gates, over.
Okay. You don't have an Amanda Cummings out there, do you, Lisa?
No, not on Zoom.
Okay. Good morning. People against Jordan Gillingham. Jordan Gregory Gillingham, 25F 256840. Good morning.
Good morning, Judge. My name is Mr. Gillingham.
Your name, sir?
Jordan Gregory Gillingham.
All right, so defendant pled guilty under 7694A.
Correct.
Prosecutors simply indicated on the plea form that they wanted, this was the city of Flat Rock, 6 to 12 months probation. Have you had a chance to review this report with your client?
We have.
Any material additions, corrections, or deletions?
None. Anything
that you would like to say on his behalf?
Just that, Judge, Mr. Gillingham, this is a one-off for Mr. Gillingham. It's not normal, it's not the type of thing that he normally gets into. He's usually got a lot more self-control. Is that correct, sir?
Yes, sir.
And it's just both parties at the time, Judge, there was alcohol involved. Things just, obviously right now, he's staying away from her. He's got no contact with her. It was actually his decision to kind of split from the alleged victim here, Judge. And he's had no other priors. We asked the court to take that into consideration.
Anything you would like to say?
Honestly, Judge, I'm just trying to do better and everything. I've just been focusing on getting my life back on track, staying out of trouble and stuff. So I'm just trying to stay on the right path right now and get all my responsibilities that the court finds and costs all taken care of.
Okay. I mean, you ever think about going back to get your GED?
I was gonna get it when I did military school, but they stopped doing my GED classes the year I got enrolled into the military school. But I had thought about it.
I don't want to get too personal here. What's the nature of your disability?
Just a learning disability.
All right. I'm going to place you on probation for 12 months. Here are your probation terms and conditions. If you can just bear with me for 1 second. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs. I'm just gonna make that on demand. I'm not gonna order treatment for alcohol. I am gonna order the domestic violence program with 8-week follow-up. They're recommending 26. Your conduct was not very good here, okay? I mean, let's just be candid about it, but I sense that you've got some remorse, and that means a lot. No contact with the victim, Amanda Cummings. You cannot write, phone, see, text, email, or communicate with her, or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. No firearms, no dangerous weapons. Do you understand that?
That's your.
I am taking this under 7694A. And, you know, it says that it's pretty violent. It says you threw her to the ground, right? So, I mean, I'm just going to order 4 days jail, credit 1, serve 3, and I'll let you serve those on the court work program, okay?
Yes, sir.
Credit 1, serve 3, 3 days court work program, $35 a day charge for each one of those for a total of $105. 100 fines, 175 costs, 75 victims' rights fee, $50 justice assessment, $400. Screening fees 60 for 460. Probation fees are $240. Plus the court work program fees. Everything included is $805. If you violate, your probation could be revoked. You could be incarcerated for 93 days. I'm taking this under that statute. If you're compliant at the end of a year, this case will be dismissed. Do you understand that?
Yes, Your Honor.
All right, you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. I'm going to give you a review hearing date. You're going to come back on that date. And again, as long as you're compliant, the case will be dismissed. Make sure you put that date in your calendar. You have to show up.
Yeah.
The date is going to be on
July 9th at 9 o'clock.
July 9th
Okay.
of 26 at 9 o'clock in the morning, okay? So about 50 weeks from now. So put that date in your calendar. We'll give you a notice down the hall, and you'll meet with probation then to go over this order. Do you have any of this money to pay?
I was gonna see if I can get, set up on, on the first of the month.
He needs a payment.
Yeah, I understand. How much can he pay?
Can I do like 150?
Yeah, absolutely. We'll make it. You sure you can pay that much?
I'll do 100 even.
I'll tell you what, $100 monthly beginning on August the 7th, okay? And the 7th of every month thereafter, all right?
You get your check on the first one.
Yeah, correct.
Okay? Any questions?
I just have one question for you. Now I do, have, like, I was just wondering, I know you said no marijuana. I do have a medical card.
Oh, you do?
Yes, I do.
Well, then I'm not gonna violate you if you test positive for THC, so long as you possess a valid medical marijuana card.
Yes, sir.
You're right, I did read that, and yes, so you just have to provide proof to probation that you have a valid medical marijuana card.
Yes, sir.
Okay? Any other questions?
No, sir.
Best of luck to you, I wish you
Thank
well.
Have a good day.
Go down the hall, get your notice, and then over to probation. Curtis Brent Hamadi, 25R513926A.
Judge, did you want to have Beth come in on this one? Because I think this is the one where she had to run, make sure one of the convictions was accurate.
Sure, call in Beth. Did you go over and get printed?
They already had my prints, Your Honor, when I went over there to Gibraltar. They said that Rockwood had sent them over to them. But I did go straight over there the day that you sent me.
Your name?
Hamadi's the last name?
No, your full name, please.
Oh, Curtis Brent Hamadi.
Yeah, good morning, Judge.
Wait a minute, go ahead, Counselor.
Good morning, Judge. Mazza, on behalf of Mr. Hamadi.
I don't know why they would have said that. Lisa, this is not on his criminal history.
Yeah, I saw that. That's why I stickered it.
You
I
gotta
can,
get
if he
print-
went over there, I can follow up with them.
I do remember them taking my prints, Your Honor, when I was over there.
When?
When I was arrested.
This was a blood draw. They took you to the hospital.
I mean, at Gibraltar.
Not this past time, before, right?
Yes, I'm almost positive.
Wait a minute, slow down. When you were arrested on March 17th,
Yes, sir.
they didn't take your prints, did they?
I thought they did, Your Honor. I could be wrong.
Well, why didn't you go over and get your prints taken like I told you to?
I did. I went straight there last time when you sent me and I waited in the lobby. I checked in with them. They came to the window and they said, we don't need you. We have them. Rockwood has them. And Rockwood was going to send them over.
Lisa, can you make a call, please?
Yeah, I'll check into it.
Yeah, I'm gonna have him have a seat until we figure this out.
That's not your justice.
Judge Officer or Detective Mercier is here in the building. That's who I would call.
Oh, wait a minute. Hang on a second. Why is this like this? Hang on. They did take his prints. Why is that not on the other criminal history that you ran on the 16th? There's only 2 pages to that and they're not on there. And the one attached to the pre-sentence report has it on here. That's weird.
What's the date that one was ran?
May 15th.
Oh, that is strange. Well, I can have them correct that. I'll check into it.
All right. Your name?
Just hold on, on behalf of probation, Your Honor.
So I adjourned the sentence until today. I ordered him to go get prints. What is going on here? I don't get this. I ordered him to get prints on the 26th. Which conviction did he say was not his?
The Arizona conviction, Judge, the one from 1999. And then he did mention to the court that he did try to get that removed from his criminal history. They told him that he would actually have to fly down to Arizona, go and physically get the documents and then submit those to the court, correct?
To the DMV in Arizona, yes. They said I needed an abatement form.
So you're saying the 1999 conviction was not yours?
Well, he was never charged, Judge. He was never convicted, right? Nothing ever came of it, correct?
Yes.
So I adjourn this to have Ms. Wilds look into it? Is that what
Correct.
you're telling me? I didn't make very good notes here, obviously.
Yes, Judge. No, you adjourned it.
Do you know if she checked into that?
I don't know if she checked into it. Everything I have in the file is from what you have there and shows a Michigan licensing, nothing out of state or anything like that. She didn't receive any notes or anything like that. She's out today. I don't have anything here in the file that indicates she did look into it.
And you're saying I told her to?
Correct, Judge. I do recall that she said she would make a phone call to try to follow up on that.
Oh, I hate to adjourn this again, but that's important to me.
She did, you know what, Judge, Your Honor, it looks like she had, if I could approach, this looks like a Arizona driver registration response, and it doesn't show that anything comes up on it. But that's the only thing in the file, so I don't know if that's what she looked into. There's nothing indicating here she made a phone call or anything, though.
Boy, I am just lost on this one. I mean, it also shows a June 13, 12 conviction out of Arizona. Do we not, he acknowledges that that's a conviction, right?
What year, Judge?
2012.
2012.
I believe that was, I thought that was in January, but I do have a 2012 conviction for DUI, Your Honor.
And you also have one out of Florida from 2012.
No, Your Honor.
What is going on?
I've only had one DUI in my lifetime, Your Honor, and that was in 2012 in Arizona.
I don't know where she came up with all these convictions at then. If it's not on here. You didn't get anything expunged, did you?
I did not, Your Honor. I guess I should have.
Well, you got one here. It says. This is weird. This is default judgment guilty on an OUIL. How do they have a default judgment on a OUIL? You don't. And then that was 99 out of Arizona. Then they show another default judgment guilty in 2012 for operating while intoxicated.
Judge, Mr. Ahmad is indicating that the Arizona conviction for the OWI is the only one he's ever gotten prior to what we're here for today.
This is strange. Well, where did she come up with the... Jeez. There was one February to 12, according to his record, operating while intoxicated, default judgment, it says, which doesn't make any sense, jurisdiction Arizona, but she's got that one out of Florida on this report. Do you live in Florida?
I did, Your Honor.
I don't know what to say here. This is important to me to know what's going on. Mr. Hamadi, I hate to do this. I'm gonna have to adjourn this. I'm sorry, again, and it's...
Your Honor, would it be okay if I traveled to Phoenix where I already know where I have to go to get that paper and have it done? And I'll try to do it myself. I'm gonna try to come up with the money to fly.
I hate to have you do that. It's not even on your record here.
No, and they can't even find a case number. I've talked to several different
How could
people
this be
over there.
default judgment? I don't know what there's no default judgments on drunk drivings. There's no false. Look, why don't you not fly across the country right now, okay? I'm gonna adjourn this sentence. I'm gonna have, but you gotta talk to her to check into these.
I'll have her do so, yes, Your Honor.
And I need her to note the file, okay?
Okay.
In case she's not here next time. Give me a new date, Lisa. I just do not feel comfortable without knowing the specifics here. I just don't.
August 7th at 8:30.
She's not out for too long, is she? She's not
No,
out.
she's just out today. She'll be back tomorrow.
I'm just gonna say, this just doesn't make any sense. It makes absolutely no sense for somebody to write or for there to be a default judgment on a drunk driving. There's no such thing. I don't care what state they're in. It's not. So that's what we'll do. I am really sorry. Don't go flying across the country until you talk to Beth.
Okay.
And let's see what we can figure out and tell her to stay in touch with me on this, okay?
I will.
If I need to adjourn it so he can leave, I have no problem. All right?
Thank you, Your Honor, yes. I
Thanks a lot. Sorry about this, Mr. Hamadi. I really am.
It's okay, Your Honor. Thank you.
All right, thank you. People against Ferguson. Kelly Ann Ferguson. 20R511787, 19R511211. things. Make sure she stays in touch. Ms. Ferguson, your name? Counsel. So we have a couple of interesting issues here. She pled no contest to assault based on a lack of recollection.
Correct.
On June 26th. I did not order a pre-sentence report on that. I did have a pre-sentence report, screening and assessment prepared back on the other file, which is child endangerment.
Correct.
And it's gonna be one of those days, I can tell. Ms. Ferguson, I ordered you to go for prints on the assault case.
Yes,
Did you go?
yes,
What is going on here today?
yes, Rockwood did tell me that they were already at file.
Same thing they told Mr. Ahmadi.
What's going on over there? Get
They don't,
Lieutenant.
they
Get,
send all their prints to Gibraltar now, so I'm not sure what the issue is.
get Lieutenant Rick here. Lisa, on that Hamadi case, I'm even gonna have him come down. Can you come up here, Lieutenant, please? Your name?
Detective Senstein, Ricky Rock, please.
So listen, I don't know what's going on with the prints over there. I'm perplexed. I just called the case with Hamadi, Curtis Hamadi. I got one lean printout that shows that he was printed, and another one that was run July 16th that shows he was not printed. It's not on his criminal history, not on his lien. I just had this young lady, Kelly Ferguson. I told her to go over and get printed June 26th. She says she did. I don't know where that one is. It's not on her criminal history.
Well, they said they'd already had one on file, Judge. They never actually printed her that day.
Yeah.
Well, I don't see that one on file.
That's the same thing they told Mr. Ahmadi, because he went there and he said that.
Something's awry here.
Yeah, when we look in our in-house computer, it shows her live scan.
Yeah, but why isn't it on her criminal history
That
then?
I don't know, Judge. She was printed on this case. I'm the one that told her she's starting to print it on.
On the assault case?
Yes.
Yeah, but something's going wrong here. I mean, I'm not pointing fingers. I don't see anything with Rockwood Police except the May 24/19 incident that's on her. And that has to do with the child endangerment charge that I had with her, for which she is Lisa, can you run that again while I'm sitting here, please, her criminal history?
Sure.
I don't know what's going on, but that's troubling because on an earlier lien on the last case, it showed that he was printed. The one in mid-July that we ran shows nothing of the sorts on this OWI charge. So I'm just completely confused, to be honest. I'm not even sure. Okay, let's wait and see. You're all set. Thanks. If we need to talk to you, we will. I mean, maybe Lisa can shed some light on this.
Okay. I'll be here.
I just don't know why they're not getting on the criminal history, I guess, is the deal.
Yeah, I'm not sure.
Okay. Let me see what I can do. Thank you.
No, it's not on there, Judge.
Yeah, see, it's not on. Why is it on? Do you have any explanation? Anybody? Lisa, can you give me any idea why?
I believe we can contact MSP and see what happened. I had this happen with Brownstown once, and they were able to look at it and see what the issue was.
I mean, I just don't feel comfortable. I don't feel comfortable going forward here until this is resolved. I just don't. I'm so sorry, but.
This would be the third time that it's been adjourned, just like Mr. Armani said.
Well, the third time that this was adjourned? Well, we adjourned it because she was in the hospital on May 15th, and then we adjourned the pretrial to June 26th.
I think it was adjourned once that because it was power failure.
Yeah, I know.
Just like I was in the hospital and
Well, I revoked her 777 status on the child endangerment. So I have to sentence her on that. I have to sentence her on the assault charge. I don't know what's going on.
You know, put them off the same day as.
I'm so sorry.
Day.
I really am. But I just have to. I'm sorry. Jeez. I mean, what did I set that other one for, Lisa?
August 7th at 8:30.
I'm really sorry about all this. And then you guys were waiting this morning on top of it. All right. That's what I'm gonna do. I'm so sorry, okay? My apologies. Okay?
No, thank you, Judge.
Thanks.
Doge's fault, Judge, that's whose fault it is.
What's that?
Doge, it's because of them. Or artificial intelligence, one of the two.
Sean Nicholas Cardinal. 25F244251. Is Sean Cardinal here or Attorney Lee here? Is that, am I reading that right?
Yeah, there's an attorney out there on Zoom.
I'm here on that matter. Good morning.
All right, your name?
Marissa Boyles?
You're here for Mr. Cardinal?
Yes.
You're authorized to enter this plea to impeding?
Yes.
To that charge, responsible or not responsible on his behalf?
Responsible.
195 is the fines, the original charge dismissed, and I'll give them till the 31st to pay, okay?
Okay, thank you, Your Honor.
Have a good day, thank you.
You too.
Can I see the docket? If you guys want to go ahead, I'll meet you.
No, Judge, I wanted to let you know Mr. Pop's turning himself in, so
Let's lock them up.
Take him into custody, right?
Yeah.
And
Were these all set? Amadi and.
Yeah, we're gonna take it down there. Lock them up.
what do we make about 11:20, 11:30?
Sure.
11:30, all right, six star, right?
What happened though, yes, what happened, I had to meet with the new state court administrator.
Who's the new state court administrator?
Well, for our region, Judge Coleman.
Oh, I didn't know
Yeah, real nice guy. I really
that. I
had.
thought you were gonna say that Boyd.
But anyway, I didn't get out here till 9:30, which I haven't done in
Judge, this is a good.
20 years. Yeah, so 10:30.
Mr.
I've
Pop's
got
gonna
my
leave his
message.
car here, we're gonna run, take care of a case of Lincoln Park, and
And I'll see you there about 20.
Yeah, all right.
Sounds good.
All right, Dr. Pop, let's go.
See you guys.
It was nice, I mean, I took him back to show him all the places he used to be when he was a rapscallion. I like the word awry, that was a good use of that word, I haven't heard that in court in a long time. Were you reading like Charles Dickens last night or what? It was the best of times, it wasn't the worst.
Have a good one. I'll see you over there, guys. Take care.
And Stephen Allen. Did Stephen Allen say here? No? There's no answer in the courtroom. I asked the bailiff to call into the hall for Stephen Allen, please.
Put whatever number you want on there.
Over 10 on the third degree, I would do 2 over 5 on the books.
You got a third one.
You Stephen Allen?
Yes, sir.
So I would do.
Have you talked to Mr. Kimbler lately?
Yes, sir. I talked to him the other day.
Okay, he's supposed to be here, right?
Yes, sir. Yeah, I don't know. I guess.
Well,
So they did it.
Word, I'm not sure.
Yeah, we're just as important as any other court.
So I talked to him 2 days ago.
But not this morning. You haven't seen him.
I was about to call.
Yeah, go ahead.
We talked about it.
Yeah, please.
I think they don't know how to cope.
That's the one that I offer.
Hey, tell him I said he was late. That'll get him up there.
So that's what we're gonna talk about when we get through.
Hey, Alan,
Yes, sir.
on these, on the guys on the contempt thing?
Yes, sir.
Okay, here's. What happened? On that, just to get you up to speed, because you may or may not know that actually occurred. So we had 2 murder trials going.
Right.
One time. We had a weekend, 1 murder, then the last juror remained, then we had 2 alternates that had to replace other jurors, and then so we were stuck with 12. At the end of the week, we still had a few days left of trial. One of the jurors had to go. The conductor from Lamar was conducting it on Broadway or something, and it was a big deal. And I said, sure, not a problem. And when they came back and had a verdict yesterday, and a sentence. But so we broke that, went into another murder case. And anyway, what occurred is we had right at lunch, and verdict comes in on guilt or innocence on this case. And this is the shooting, the 88 bullets over in that we were just talking about in near Gillum Circuit, a murder case. So sentenced, and then David Grove had some pleas. And so I said, all right, we're in recess. David, let's get these pleas going. And because we got to come back for sentencing beginning that. And everybody's leaving, and then all hell breaks loose right there at the door. Right at the door. And I'm shouting, screaming that I lost my bailiffs. The hearing had to be postponed, couldn't get interfered with that. And banging on the door. Then they came down with a video and they got a video. I mean, we got more cameras in this courthouse than I ever knew. And there's a camera right up there. It's clear. It shows before it happened, as they were leaving, and they begin to, somebody says something, and then they all got into it. Fisticuffs. I mean, and it's cameras within a few feet looking down, and all hell's breaking loose. So I brought them in and chewed them out a little bit about and also the camera. Some jurors were right there. Right there. You can see from the camera in the background, the jurors are watching what's going on, which threatened the whole trial. So put him in custody, and then I went and did some research real quick. And I'm gonna give you this case on ex parte Daniels, which is what I'm using as the basis here. This is a hybrid. You've got direct contempt and indirect. I'm not telling you. Direct happens in front of me. Indirect, it's not, but it affects the proceedings. Then ex parte Daniels carved out a third situation where it's direct is it happens in the presence of the court, but they define presence as I don't have to be. I don't have to. It's if it interferes, if it's at the doorway with the court proceedings, and it is directly affecting the court. Court can hear it, or it has effect. Then it's handled as it is handled as direct contempt rather than indirect. But because we had 2 murder cases going, I brought them in and I ordered a bond, $1,000 on each of them. I think they all posted the bond. And it was just a fire we couldn't fight at the time. I had to postpone it. So we've gotten, that's the damages that was done that all 3 are going to have to pay a part of ultimately. But what I'm planning to do, I'm holding it. I'm going to consider it as a postponement of a direct contempt proceeding and dealing with it as direct. But they need to, they're going to have to, my plan is they're going to have to pay the restitution, not the taxpayers. They're going to have to pay because I saw what happened, and everybody should have walked off. But it just, they couldn't do it. And you can't be throwing haymakers right at the doorway in a hall of honor where we're supposed to resolve controversies in an adult-like, intelligent, educated fashion. And it's like a barroom fight going on right there. It's terrible. And people are seeing this, and it's not a good public relations moment for any courthouse in America. It stands for. But anyway, so I said, I can't do this. I ought to be holding a hearing now, but I'm going to postpone the hearing. I'm going to allow y'all to post a bond because I've got these 2 murders that have to get moved, and we finally resolved them yesterday. Yeah, all finished with the verdict. So I'm bringing them back in here to pick up a direct contempt proceeding, which is a unique way of doing it. But there's not a lot written on it. But this case is perfect on it fits the circumstances of what we had. And they said, and the Court of Criminal Appeals held this was direct, even though the judge isn't watching what's going on. If he can hear it, it's at the doorway, and it affected his proceeding, then he can deal with it as a direct contempt proceeding.
Can I tell you kind of my position, Judge?
Yeah.
I know Mr. Nichols. Actually, I grew up down the street from his family when I was a kid. And so he reached out to me and said, hey, I got to be in court tomorrow. I'd heard about the fight on the news, but I didn't know who it was. And it
made the news, didn't it?
Yeah, he told me a little bit about it.
Well,
And
that
showed,
ought to be
showed,
easy to
showed
get.
the broken chair.
That ought to be easy to get jurors.
So so I'm like, I don't, he told me he had to be here. I'm like, what for? He said, well, you have a hearing on this contempt charge. I'm like, so I got him looking at the computer. It says in the computer, it says they posted $1,000 bond. It says a contempt class C. So I don't.
No,
so
that's wrong.
I'm just saying what the computer says.
No,
so
it's
I'm not saying it's not wrong. I'm just saying
they reported that it's not a class C. It's going to be, it's a class A misdemeanor. It's a regular.
Right.
It's not class C. It's a regular. Even though the damages aren't much, that's not the issue. The
Right.
damages are just restitution
Right.
that are part of the harm that was caused that everybody's going to have to pay for. But he's looking at up to 6 months, a regular contempt, up to 6 months in jail, and I think there's a fine that can be made. But this court isn't intending to throw the book at them.
Right.
But everybody's going to have to get assessed and punished. To set an example, you can't be fighting and haymakers here that interrupt the court, or also threatening the sanctity of jury trials when the jurors are watching. That's all we needed is to reverse that because of foolish behavior where people can't conduct themselves as adults in this building. And that's what we're supposed to be doing. But it's going to be, I'm handling it as it's a postponed direct contempt proceeding. They're not even entitled, he's not even entitled to an attorney, but
Okay.
you're certainly invited to.
Well, that's
present.
I've never I've never handled contempt. That's what I told them. I've never handled it. And I was going to ask for time to talk to them. We haven't arranged a feeding together.
There's two.
Video.
The other two guys are supposed to be here too.
There's one of them's outside. Well,
are those?
That's the father's son.
And then the other one, yeah, it's best that the other ones stay separate.
Right, they were sitting next to each other, I guess. So I mean, I haven't seen the video. I haven't seen anything.
Dennis was going to be getting the video.
They have it, but
I have the video.
But is there any way we can reset so I can talk to my clients and?
Why don't you look at the video and
to be honest,
I've got some things I've got to conduct
first. Are they
first.
formally charged yet?
I charged them orally. It's not a written charge. You don't get an indictment. It's something when it's direct contempt.
Do they have a right to a jury trial?
No,
they don't.
No, you don't have a right to a jury trial. No, you don't. Not on direct contempt. No.
So,
but when we get into this hearing, everybody will know where I'm coming from and what I've got. Murder cases I'm dealing with. This is a sideshow. That's ridiculous. And it's going to, I'm not going to spend a lot. I don't intend to spend a lot of time on it. I want the money back. And how long were they in jail? Did y'all stay in jail at all? Did you stay overnight?
No.
Yeah, they're going to go to jail for a couple of days. Everybody go, you don't fight in here and get held into.
So there's no need for me to
not go to jail. Actually, you can be here and help talk to them and explain to it, and you're always invited. You can be present, but we move forward, and I always am interested in if an attorney wants to be present on somebody's behalf and talk for them. That's great, but they're not entitled to it. It's direct contempt.
Well, I mean,
I could have taken care of the hearing had we not had the situations, the fires going at the time. But I couldn't spend the time on it to deal with it. When we had 2 murder cases at the same time, those were far more important than a disruption that was ridiculous. And it's in the great scheme of things, it's minor compared to murder cases and everything else that goes on in this building, but it has to be attended to and there has to be a sanction so that the example is set that we're going to deal with our issues in a humane, sophisticated, adult-like manner, not throwing haymakers at the door and banging into the door and interrupting the court's proceedings and then having jurors watch. I mean, We're fortunate it all didn't all fall apart and we had to retry murder cases. That would have been catastrophic. We just don't have we don't have the wherewithal to pay for the same real estate twice. Man, that's where it stands on all of this. And
I'm gonna have to take them outside and talk to them about that, and then I would assume the court would, if the court is going to try to put them in jail, bring down. Assume the court would take into consideration.
I mean, those are my options.
If they got jobs.
I know, but you pay for a mistake. You can't be fighting in the courthouse.
And I would also think they would make a difference who started it. I mean, of course, I haven't seen the video. How it happened.
I see what happens. I mean, I'm not hearing it, but it doesn't matter. Words aren't important when you're talking about that.
Okay.
I saw it's clear what happens, and everybody should have shown some self-restraint, but hey, they're in a murder case too. And everybody's emotional. There are 88 bullets were fired in that episode. I mean, it was a terrible thing for Port Oregon, for Jefferson County. People die. It's terrible.
Yeah,
it's terrible. No, it's terrible. And like I said, I played right there. I used a block away from that was my grandparents' house, a block away. And my dad grew up there. I played in the.
I can imagine. I mean,
anyway, I never heard gunshot.
It was the son to dad.
No, it's terrible. It's terrible. But nonetheless, 3 people are scuffling and banging, committing disorderly conduct right there, and it has to be accounted for. But I understand I understand some of the other facets. I can put somebody in, I can sentence them to 6 months in jail. That's not what's going to happen. I don't tend to do that. But there has to be a sanction where you don't fight in the courthouse. And interrupt the court proceedings and threaten juries that may have to be reversed because jurors are watching. There's so many bad things that can happen from a fight in the courthouse. It ripples across different segments, and we can't try cases over again here. We're the 22nd largest county in the state with the 16th highest crime rate. We're fighting fires everywhere. And it's the people need to start acting together, adult-like, and following the rules and handling their problems in a sophisticated adult-like fashion, not like we're at elementary school and you got a fist fight on the playground. It's just terrible. It's not this example that has to be set up here. And we're going to set examples that are the right things to do. And you commit assaults, you're involved in assaults, you're going to get sanctioned. And like I say, it can be up to 6 months, but that's not what I intended to do. But I'm going to, people need to get sanctioned, all of them. So I saw what happened. And there are videos here somewhere. You can look.
I'm going to talk to him and see how it's, if I'm going to help him or.
Okay.
What?
Okay. Thanks, Alan. Hey, David, speaking of these guys that are here on that contempt matter, that was your case you were trying to plead. What happened? What are we gonna do about that case that got interrupted?
We took care of it, Judge.
Judge, did it get disposed of?
Yes.
I'm not sure what case we're talking about. I'm probably.
It was taken care of.
Remember when all hell broke loose, when they were fighting outside and the bailiffs had to take off? You were doing a plea.
I was up here, yes, sir, I was a plea.
And then we had to interrupt that, but we didn't complete it.
Okay, I thought you indicated that
Yes, we did.
When did we
We came back in.
Other case.
Okay.
Yeah, I think it is disposed of, Judge.
Yeah. She said we finished it later. During lunch. Okay.
Mr. Holmes to step over here.
Holmes.
Alan, let's sit in the back.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. Ink up your right one friend. This is a flat right here. Ink it up one more time. Please go right here. Okay, Judge. Mr. Holmes and Mr. Allen are both ready.
Mr. Holmes? Yes. Who's your attorney?
Me.
Is Brady. We now call cause number 23 CR 669, the state of Texas versus Riley Lee Holmes. Who is present with his attorney, Brittany
Yes.
Holmes. Y'all aren't related?
No.
Oh. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about March 17th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with in this indictment?
Yes, Your Honor.
Right. It's like there is an agreement that you would be pleading guilty to the lesser included offense of eluding.
It's gonna be the transportation code.
What section is that?
545.421.
Five.
45.421.
Huh.
Mhm.
You sure? Because it's not in this.
Transportation.
In the transportation goes, it goes 524.051 to 550. Goes from 524 to
I just
550.
changed it from what I was looking at. 421. Yeah, I'm still going. 47, 420. Gotta keep going, because it's right there. Fleeing or attempting to elude a peace officer, 545.421.
Yeah, it's just,
Yes, sir.
it's not in this. It's
Here,
not in the book.
here's the code section, Judge, if you want to look at it.
No, that wasn't included. According to section 545.421 of the Texas Transportation Code, a person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Except as provided by subsection D, which is that it would be a class A misdemeanor if the person is recklessly engaging in conduct that places another in imminent danger of serious bodily injury. It is otherwise a class B misdemeanor.
Yes, sir.
Right?
Yes, sir. That's correct, Judge.
Which means you face no less than 180 days.
Up to 100.
Up to 180 days in the county jail and or a fine not to exceed $2,000.
Yes.
Do you understand what you are charged with and the punishment range that is, this says a fine not to exceed 4,000, isn't it 2,000?
It's 2,000, Your Honor.
Yes, okay.
Are you up for?
An agreement has been reached where you would be pleading guilty, sentenced to 30 days county jail. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes.
You know, this pad is odd.
I know, but this other one's acting out, Judge.
Okay.
October 1st, we're supposed to be able to order our new tablets. New budget year. But hang on till then.
So again, how do you plead to this, guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. If you need to sign at the bottom.
Oh, yes.
I hope it'll work. That stylus is not friendly with the pad.
That's your signatures. There, in there.
Did you sign that document?
Yes.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into
No
evidence
objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes, is a pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement. I have nothing further and find you are pleading guilty to this lesser included Class B misdemeanor of eluding law enforcement voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this Class B misdemeanor, and following this agreement, you are hereby sentenced to confinement to the county jail for 30 days. You will be given credit, of course, for time you have served. You understand what has happened today?
Yes, sir.
Have you served more than 30 days?
No.
Yeah, no.
He only has 5 days.
Okay, well, he's got to be ordered to report.
Yes, sir. He's going to go to
When?
custody.
Immediately? When, we got to figure that out.
Mm-hmm.
You gonna go into?
Get it done.
Today my son's birthday, but
Can you go tomorrow, Friday,
yeah.
at 6 o'clock? Can he report Friday at
Yes.
6 o'clock?
But you need to hang around till they take that monitor.
That's fine.
Also, don't fail to do that. They're going to be expecting, if you fail, then you get into all kinds of more trouble.
I'll be there.
And then I can undo this deal, and then you're starting from scratch, because she's fashioned a pretty good deal for you.
Thank you.
Yes, sir.
Thank you.
Okay.
There's someone here to take the monitor
Great.
from you.
Okay, thank you.
Okay, wait.
And then I can.
No, you can come on back here. They're here. Thank you. So. Hold on, 31.
Stephen Allen. Here's this. Thank you.
Yeah. You want to do the aisle?
We're offering straight probation with restitution.
22-40573 is now called the State of Texas versus Stephen Dustin Allen, which is you. Present with Mr. Kimber, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
So waived in your name.
In summary, this indictment alleges that on or about June 29th, 2022 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of metal or body armor by being a convicted felon. As of 2006, you convicted in this court of the felony of fraud. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this third-degree felony? Guilty or not guilty?
Yes.
Or you? Both?
The timing was funny.
I understand, but I thought it was ironic both you and your attorney pleaded guilty.
I can possess money.
Which is
If he wants to take the case. No.
something that's overdue, long overdue for him.
I can legally possess money.
Are you pleading guilty, Mr. Allen, voluntarily and because you are guilty?
Yes, sir.
Oh, I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You got it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. Thank you so much. All of this is true, state, so help you God.
Sir.
State's Exhibit 1 is part of the record without objection and admitted. Anything further? I'm going to follow this agreement if nothing further and find you have pleaded guilty, Mr. Allen, voluntarily. You're not only competent to do so, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of body armor. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, there's a fine of $500 attached to this. Please do well. We can get it shortened in a third. Okay. Anything else? That is all. Thank you. Please see the probation officer.
Got to do that I-1 Ernest class.
Let's pick up the matter of this contempt. Where's your, where did Alan go? He just walked off? Did y'all talk to him?
Yes.
What are y'all gonna do? Go without him?
Yes.
All right, come on up.
On the credit card.
And I've also,
She made bond.
where's Mr. Angel?
Message.
All right, we need him to. Here, can you make some copies of this, please?
You have to have more than five.
Actually, the damages were far less than I thought they were gonna be. 8,000. I thought it was gonna be 2,000 or 3,000.
Combination.
But still, you don't pay a dime. Somebody wants to pay any money for, you know. It ends up being 500 something divided 3 ways. It's the way you're gonna do it. Come on up. Just go on up, sir.
That would be like a presumption. You get a jury.
All right, we call, you're staring out and jail. You have to speak up, sir.
Yes.
Thank you. And Charles Nicholas Senior.
Yes.
And Charles Nicholas Jr.
Yes, sir.
Oh. On July 18th, which is 6 days ago, last Friday, this court was in court session on the case of Stephen Angel as a defendant in a murder case. And the jury had returned a verdict finding the defendant guilty of murder. It was about lunchtime. We broke for lunch and I ordered the jury to return back and the parties to return back after lunch to begin the punishment phase of the trial. While we were in that phase, Mr. Grove And the parties were exiting the courtroom. Mr. Grove, David Grove, one of our public defenders, was proceeding immediately into a hearing that we were conducting on a plea. And what was the case, David? Do you remember the defendant's name?
No, sir.
Okay, because you do a lot of them. Thank you. Here. Everybody gets one of these. You got one of these. You give this to Mr. Andrew. Thank you. And as the parties were exiting, Mr. Grove was beginning to get this plea underway, and then we were breaking for lunch and we were going to return back. The jury was just exiting here at the doorway. The court heard voices, loud voices. There was a slamming and bumping up against the door. The bailiffs rushed out to take care of what was obviously a disturbance going on at the courthouse door. And the court had to terminate in the middle of the hearing and postpone that for a later time as we were resolving what the disturbance was. So the court walked out and then saw the three individuals being arrested. And these were family members of the Stephen Angel case matter, people who were involved, victim, defendant, three people related to the parties. The court, in just a matter of minutes, actually received a copy of the video of the proceeding. There's a camera right over our doorway. And I looked at that, and it was plain to see what had happened, where three people, the parties involved in this matter had gotten into a confrontation, and shoving and the throwing of fists were part of a fight that was going on. Involved was Charles David Nicholas Sr., Charles David Nicholas Jr., and Stephen Angel. Unfortunately, these are Mr. Angel is related to the defendant, and then the Nicholases are related to the deceased in the murder case involving Stephen Angel that the court was in the middle of and had just received a verdict. So the court brought the individuals in because the court was in a multitude of important matters at the time. We could not fully conduct a hearing on that matter, but the court reviewed and is following the Court of Criminal Appeals decision in 1987, Ex parte Daniels of the Texas Court of Criminal Appeals, which is quite similar in issues and facts to the issues in this matter of contempt, as the court ordered them to be presented to immediately come before the court, and the court orally charged them, the three individuals, with contempt. And the issue became, is it direct contempt or constructive contempt? That is, direct contempt or indirect contempt. Direct contempt occurs when it occurs in the presence of the court. Indirect is a matter that occurs outside the presence of the court, but in each case, disruptive behavior, committing a crime, failing to follow a court order, all of those are part of the equation that the court has at its disposal in dealing with matters to ensure that the court's business is conducted in a civilized, peaceful, lawful fashion. The big question, the big issue here on this case is direct contempt versus indirect contempt. Direct contempt involves behavior which occurs in the presence of the court. The court was sitting where it is now on this bench, in this chair, and the people in the court had been recessed on the murder case on Mr. Angel for lunch, and we were return afterwards to pick up the punishment phase. And at the doorway, the court, as people were leaving, the court then was, as Mr. Grove was beginning his plea with his client, the court heard loud noises, shouting, banging on the door. The bailiffs in my court exited quickly and moved toward the noise and exited. And this hearing had to be stopped. So it interrupted the court's hearing that was being held with Mr. Grove and his client. But yet, the court went outside and saw these three individuals being detained by law enforcement. The court saw some jurors watching from a vantage point not far. I noticed some of the jurors were watching and from that murder case, and then they left. There was damage to the chairs outside the courtroom, and then the court brought the three individuals here today, Mr. Nicholas, and Mr. Angel, and then spoke to them about their actions, which this court deemed to be disruptive and in contempt. The court had also, within just a few minutes, 5-10 minutes of the event, received a copy of the camera recording of the scuffle, and this court picks up from when the parties were leaving this courtroom at the doorway, and then this court saw, even though there's no audio to it, the court saw the confrontation begin, then turned shoving and punch throwing. And then authorities intervened quickly. But at the conclusion of all of this, what had happened is this court's business was disrupted. The scuffle is occurring at the doorway of the courtroom. Jurors of this case were in the vicinity and could see what was going on. This is bad in many different ways, and this isn't the way the rules of procedure and the rules of handling matters in this courthouse are supposed to be handled. So, to preserve the Court of Criminal Appeals, the highest court in criminal cases for Texas, has stated that to preserve order in a courtroom for the proper conduct of business, the court must act instantly to suppress disturbances or violence or physical obstructions or disrespect to the court when occurring in open court. And there is no need of evidence or assistance of counsel before this court can exercise its enforcement and punish those who are disruptive. And this is all concerning the dignity of the court and the authority that is necessary for us to resolve issues in a nonviolent, higher educational level method that the justice system is supposed to be a part of. Now, the question becomes whether this occurred in the presence of the court. And this court decision, ex parte Daniels, 722 Southwest 2nd, 707, which is a 1987 case, a decision by the Court of Criminal Appeals in Bonk, that is the whole court made this decision because they felt it was important that all the judges be heard in the matter. And the issue became, did it happen in the presence of the court? If it's in the presence of the court, I can deal with it immediately, or I can postpone it like I've done and deal with it later. But in that special scenario, that's called a direct contempt proceeding, which the parties do not need a lawyer, aren't required to have a lawyer. This court can deal with it as soon as it's expedient. If it's not in the presence of the court, then it becomes what's called civil contempt, which still can be punitive. But in civil contempt, the parties are allowed an opportunity to hire a lawyer and can deal with it at a subsequent time. However, this was a case that occurred dramatically similar to the situation here. The question becomes, what does in the presence of the court means? And the Court of Criminal Appeals ruled this way. The presence of the court does not necessarily mean in the immediate presence of the trial judge. The judge has, the court has held that the court is present and things happen in the presence of the court whenever any of its constituent parts, the courtroom, the jury room, or the doorway, are involved in, or all involved in the work of the court. And it is for this determination and reason that the courts have held that you can be committed to direct contempt proceedings when someone is just placing publications, contemptuous publications, in the corridors of the courthouse where prospective jurors would necessarily see them. I mean, that's the far range aspect of how this court can have authority. We're not talking about people setting publications in the corridors of the courthouse that might affect jurors. What we had here was a fight going on at the doorway of this courtroom after the court had just immediately received a verdict finding the defendant guilty, and people related to the defendant and the victim were scuffling, and in the midst of an assault, it also interrupted the proceedings that the court was holding with Mr. Grove and his client, which had to be postponed and still, and then were disposed of at a later time. And then the court also lost its bailiffs that are required to be present at all times in this courtroom during its business, as they went out to immediately stop the scuffle and deal with the problem that it was having to deal with. So what this means altogether is this works just as though y'all had fought in front of me. And because we had that murder case and then we went into another murder case and just completed that second murder case last night. I've asked the parties to come before the court. The court, because it was having to deal with those more important matters at the time, did bring the parties present, then postponed further proceedings. But it's the court's finding that these are direct contempt proceedings, and this court can make its decision. Did anybody stay in court, in jail overnight? Mr. Angel, how long were you in jail before you posted your bond?
Yeah, about 2 o'clock
A few hours?
overnight, and the next.
It was overnight?
Couple
Okay.
hours.
What about y'all,
We stayed about 7,
sir?
about 7 o'clock that night.
That night, okay. But y'all were arrested, brought to jail, and then
Yes.
The damage done by this ridiculous behavior is ended up costing $519.26 to the people of the taxpayers of Jefferson County. So each of you are going to pay your part. That's $175 each. Everybody, you, Mr. Angel, and Mr. Nicholas and Mr. Nicholas, you will be ordered to pay restitution to Jefferson County. The taxpayers, Jefferson County, the county treasurer had to buy the new equipment that is now placed out there. You will be ordered to pay that. Do you understand, everybody?
Yes, sir.
When can y'all pay that?
I pay today.
How about you, Mr. Angel? How much time do you need?
Feel the taxpayers, if you want to implicate them.
No, I'm not implicating
Taxpayers-
them. They're getting paid back for the
All right,
loss.
and listen, the taxpayers' time is not only cash, money is not only cash, but time is money. And money is time. So I feel they can get that back from me through time.
You're still going to pay the restitution. Do you understand?
I will.
Okay. Each of you will be ordered to serve 3 days in jail. 3 days in jail. Does everybody understand?
Yes.
Everybody understand? It's and ordered to pay restitution in the amount of $175. You've already served 1 day. I give credit for 1 day for each of you. So when can y'all begin the service?
Can I turn myself in tomorrow?
Sir?
Can I turn myself in tomorrow?
Yes, sir.
I just started school this week and I want.
Yes, sir. That's just 2 more days.
Okay.
2 more days. When can you go, Mr. Angel?
Today.
All right. And
I need to call my job and everything.
yes, sir. Okay. All right. Do that and let me know, and then we'll work with y'all. Also, a part of the judgment, again, each person pays $175. That was put into the equation, so the court decided you didn't need to do 6 months. But the taxpayers, we all, including you, all of us are taxpayers one way or the other in this county. But we all pay our part. When tax revenue, assets are damaged, person responsible for it, the people responsible need to pay back for the people. So the court will order each of you to pay $175. And if everybody's credited for 1 day, 2 more days at uh, at, on a time that y'all can work with. And we need to know, again, Mr. Nicholas, on you, you're gonna, Mr. Angel says he's gonna turn himself in on or before 6 o'clock today.
No, I'm just taking from here.
Well, do you want to just, do you want to turn, you're gonna get credit for the day, but you don't, you can stay out until 6.
All right, we can do that.
Okay. But on or before 6 o'clock. Yeah, your word's good enough. And what about Mr. Nicholas and Mr. Nicholas?
Tomorrow.
Okay, tomorrow?
Yes, sir.
All right, and
6 o'clock.
then you'll, that just gives you 2 more days. But please, and also, when are y'all gonna pay this restitution back? You said today?
I can pay it right now.
Okay, well, I'm not sure how that,
Judge, I'm not quite sure.
I think that-
We collect the money. I'm gonna have to make some phone calls.
I think the jail normally does that. Don't the jail collect on restitution when they're?
No, I don't think so.
No, the jail doesn't collect any money and I can't take in any money on behalf of the court. I'm gonna have to make some phone calls. If everyone can just hang tight, let me figure out how we can get the money from.
Yeah, let's figure that out because this is kind of unusual. And so we can get it done right, okay?
So if everyone can just hang tight for about an hour, let me try to figure out how to get that and get the paperwork done for them.
Okay,
And-
you can work on that right now?
Yeah,
Thanks.
yeah,
Just
no.
hang loose, not an hour, just about 20 minutes. We ought to have an answer, okay? All right. Yes, sir.
I want to apologize to you.
That's all right. That's all right. It's tough for everybody. It's tough for everybody. But every case we have, I've had 600 jury trials here. 600 I've presided over. It's hard on everybody. But the worst thing you have is to have show violence here in the courthouse when we're trying to resolve problems in a modern, sophisticated way. Now, people aren't always happy with the way things happen, but it's under rules, the rules of evidence. I helped write the rules of evidence. The rules of evidence, the Code of Criminal Procedure, there's rules. We're not cavemen that go out there and just seek our own way of justice. I mean, it's under rules, or it would be chaos. And we've developed it because that's why we're the leading country on the planet. People want to be like us in the way we resolve problems. But this building is filled with problems that we're having to resolve. And a lot of it is very emotional. Then nobody can appreciate it more. Everybody needs to know. I was in the United States Attorney's Office. I was the United States Attorney for 20 years before this. And then here going on 20 years. And James Byrd trial, I'm right in the middle of that, prosecuting that. You want to talk about emotion. Nothing was more, has impacted my life and this country than what happened in the James Byrd matter. But how did we dispose of it? How did we resolve it? We didn't just go out and just start fighting and disrupting and seeking immediate justice. We did it in an orderly fashion. And at the end of the day, people were executed under rules of order. Mr. Byrd didn't get that. I mean, he was brutally murdered for no reason except for his race. And that's one of the rules. We're all in this together, all of us. We all look different, unique. We're all unique people, all of us. But we're also fellow Americans and citizens that have to live together, not only on this planet, but in this country and deal with our problems. All of us have problems, every one of us. There's no perfection in it, but we've got the thing we have that's important is we have each other that we try to get along with. And because we're stronger when we work as a team, as a unit, all shapes, sizes, and colors. And these are emotional things that occur. But when we lose our focus and then uh, resort to violence, then the rules aren't applicable anymore. And it's, people get hurt, and it's a bad example. And it's certainly not anything that we want this courthouse and our county to be known for. It's known for justice. And that's the kind of thing that it was meant to be. Just when something bad like that happens with James Byrd, you don't just take it into your own hands. You work it deliberately under the rules and make sure that justice is served. That's what the Attorney General ordered me to do, is see that justice is done and make sure that those people are held accountable and fairness, but justice is served. Yes, I think I saluted that lady because she was that kind of lady. She was a general. But it works. I've seen it work. I know how it works. And when something like this happens, that's just a bad example to set. But yeah, I've been upset. Everybody loses composure. You have lost composure. Okay. We're fixing this. We move on. We do better, get this behind us, and be the best we can be. Anything else? Awesome. All right, let's live together, try to live together and work through this, because we've got winners and losers and victims all the way around here. And we'll put everything back together and move forward as best we can. Peaceably. Right? Yeah, everybody. That's what's right. And here we got families. Y'all know each other. And like I said, my grandmother, my grandparents, my dad grew up about a block or two from where this happened. And so I was over there all the time. I played in Gillum Circle all growing up as a little big kid. And it's not supposed to be a place where there's 88 people shoot 88 times in the residence area in a neighborhood. It's supposed to stand for something better than that. People go to live together peaceably as best we can with all our differences. Still, we're fellow human beings and fellow citizens. All right. Anything else? That is all. When we're in recess. Thank you.
This is file 21 Article 05092A, People versus Monique Kayla Anderson.
Good morning, Your Honor. Justin Zade appearing on behalf of Ms. Anderson. President consents to appear via Zoom. Ms. Anderson, can you state your name?
Monique Anderson.
Your Honor, date and time set for arraignment. We'll wait for more reading. Stand mute.
I'm going to recall the bench warrant. Reset the show cause. Is the address we have for her on Park Place still good?
No.
What is your current address?
25112 West 8 Mile, Southfield, Michigan, apartment 905.
And what's the zip there?
48033.
And your phone number, please.
313-767-0422.
Esteban, please.
Your Honor, we would respectfully request personal bond. Miss Anderson's 28 years old. She's single, no children. She's on a leave of absence currently from T-Mobile. Otherwise, I'm not aware of any violent or assaultive criminal history, no other felonies. She has a few warrants, most of which are going to be addressed today. I believe there's this one, Farmington, which we're handling in 45 minutes. And then I think there's one other traffic issue out of Livonia. She's on probation or parole.
Oh, the amount of money that she owes here is $332, I believe. And I have to tell you, Ms. Anderson, that if you would show up and tell the court what the situation is, that there would have been accommodations made. How long have you been in jail?
I came in last night, but I was at the detention center for a day, and then I came to the county last night.
Are you going to show up in court?
Yes.
Have you ever been in jail before?
No.
Pretty bad, isn't it? I'm going to set the bond here in the amount of $332 personal.
Thank you.
And again, if your financial situation is really bad, and can't afford to make the payment, when you get the notice of hearing, show up and tell the judge what's going on.
Okay.
But when you don't show up, then they issue a bench warrant that adds, I think, $75 to what you owe, and it just goes downhill. So you don't blow it off. It's a personal bond. You don't need to pay money to get out of jail on this matter. So in this matter, you're good to go today, but don't blow it off. Okay. So you're all set. If you knock down the door behind you, they'll bring the next person in. Good luck to you, man. If you knock on the door behind you, they'll bring the next person in.
Oh, bye.
Okay, we've got Ms. Price, I believe.
Yes.
Ms. Price, can you see and hear me?
Yes.
This is 25-00409, people of the state of Michigan versus Yolanda Lee Nancy Price.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Ms. Price, President consents to appear via Zoom. Ms. Price, can you say your name?
Yolanda Lee Nancy Price.
Your Honor, date and time set for arraignment. We'll wait for more reading. Stand mute.
Thank you. Are you and she consenting to conducting this hearing on the Zoom platform?
Yes, Your Honor.
Thank you. Ms. Price, you have the right to have a probable cause conference set within 7 to 14 days. And preliminary examination 5 to 7 days thereafter. You'll be notified of the date and time of the probable cause conference and the preliminary examination by mail. Are you still on Leland Street?
Pardon me?
Do you still live on Leland Street?
Yes, yes.
Okay. Mr. Zed, do you have a phone number for her?
I don't. Your Honor, she's in prison right now, so I'm not sure that would be applicable.
Okay. Currently, she's in the Oakland County Jail.
Yeah, she indicates to me that, as it relates to bond, she indicates to me that she's serving a prison sentence for a similar crime. So we are asking for just a nominal cash bond.
Is she requesting appointed counsel?
Yes, Your Honor.
Ms. Bryce, you'll need to fill out the written request form for appointed counsel.
I did.
Okay. If that hasn't found its way to the file yet. What is her out date from prison?
I'm not sure. Ms. Price, when is your out date?
It's July 31st, 27.
Bond is academic in this matter. That being the case, I said bond is academic because you can pay the bond, but they're not going to release you from prison.
Right.
Bond in this matter will be $25,000 cash surety. And then do it. Ms. Price, if you knock on the door behind you, they'll let the next person into the room. Thank you.
Okay, thank you.
Right, so ma'am. You're up. Wait this way, fellas. Paperwork? Yes, sir.
Morning. Is your name David Collins?
David Christopher Collins, sir.
And Mr. Zayed, you need a breakout room?
Yes, Your Honor.
Mr. Collins, you're going to have the opportunity to consult with Attorney Zayed in a private setting. The court will not be a party to your conversation, and that'll be done in a breakout room. And they're there.
We're ready, Judge.
This is 25-01079, people of the state of Michigan versus David Christopher Collins.
Good morning, Your Honor. Justin Zayed appearing on behalf of Mr. Collins. President consents to appear via Zoom. Mr. Collins, can you say your name?
David Christopher Collins.
Your Honor, date and time set for arraignment. We'll waive formal reading, stand mute.
Thank you. Mr. Collins, you have the right to a probable cause conference to be set within 7 to 14 days and a preliminary examination to be set 5 to 7 days thereafter. You'll be notified of these dates and time of these two hearings by mail. Do you still live on Girard and Royal Oak?
Your Honor, he just got sentenced to prison time yesterday.
Okay. And what was the length of that sentence?
Mr. Collins?
Like 18 to 120, like 18 months to 120 months.
Accordingly, Your Honor, we'd be asking for a nominal cash bond.
Presume he's requesting appointed counsel then?
Yes, Your Honor.
Under this matter will be $10,000. Cash surety, no 10%. They'll do it. If you knock
Thank you,
on the door behind you, sir, they'll let you out. Mr. Collins, if you knock on the door behind you, they'll let you out of the cubicle.
All right, you guys enjoy the rest of your day.
You too, sir.